CLE Today, sponsored by the State Bar, the CLE Committee, and the Debtor Creditor Committee. My name is Caitlin Collier, and I am the chair of the Debtor Creditor Committee. I would like to take the opportunity to ask all of the members of the Debtor Creditor Committee who are here today to please stand and be recognized. I think we have a few people here. Thank you for all of your work. And I am going to be up here briefly to introduce our first speaker, who's also a member, a very hardworking member of our committee, Thomas Ashby. Thomas is a partner in Baird Home in Omaha, Nebraska, and he's a member of their Financial Transactions Section and Bankruptcy and Creditor Rights Group. He is licensed, can you believe this, South Dakota, Nebraska, Iowa, Missouri, various federal courts, including the District of Colorado, and hopes to announce his run for the presidency in the next couple of weeks. He serves on the Debtor Creditor Committee of our State Bar. He's a founding member of the Bankruptcy Section of the Nebraska State Bar, and he continues to serve on the section counsel for the Iowa State Bar Association's Commercial Law and Bankruptcy Section. So he is pretty much the guy in the know for these three states. He has spoken at multiple seminars, and we are so very glad not only to have him as a member of the committee, but to also have him here as a speaker. So without further ado, Thomas Ashby.
Thank you. Thank you. I think all the speakers share this philosophy of learning together. I'm still learning, and if we ask questions back and forth, that will facilitate that. So please ask questions at any time during this presentation. And it's the first presentation in your lime green materials there on loan and credit workouts. If you're here representing primarily banks, great. There'll be plenty of meat in here for that. Hopefully, if you sometimes have clients that are suppliers and doing business without a promissory note, plenty of meat for that too in terms of credit. And again, we'll just start with a question for you. How many of you are lawyers in private practice? Private practice lawyers? Typically, the majority of a group like this. How many work for the government? Government lawyer? How about you work for a corporation or other non-government entity? Maybe your bank, maybe your in-house counsel. Somewhere we have some of those. Okay, terrific. And how many of you would like to help the Nebraska football linemen? Okay. We're talking about specific tips, and one of them, as you're dealing with a credit workout, okay, there's tension, there's a default of some kind, is to see if you have a lien. If you're extending credit, maybe you have a statutory lien, maybe you have a UCC, Uniform Commercial Code financing statement lien, real estate lien. But take a look at it to see if you're properly perfected, because the last thing you want to do is get into a priority dispute with another creditor or maybe a bankruptcy or something like that if you're not properly perfected. Now, some of that is basic, but I want to mention three specific ideas within this first topic. Isn't this great? And we should probably take a moment while Nicole, I think, is still here to thank her for setting us up with all this. Wherever you are, Nicole, here's our thanks to you. Three specifics beyond the basics in lien perfection, okay? You need both a security agreement and a financing statement, of course, on deed of trust or mortgage. But you gotta have, if you're relying on a consensual lien, but you have to have the proper owner as the debtor, as the grantor. So especially you people who are dealing with non-titled things, crops, cattle, inventory, things that don't have a courthouse title, make sure that the real owner is the grantor of your lien. Now, how can you deal with that in a workout situation? Because that's what we're talking about, workouts. One thing you can do is the debtor typically wants more time, and in return for more time, you can ask them to give you, a statement of property updated and that sort of thing, so that you know they own it, and it's not Uncle Bill, it's not some newly formed limited liability company that hasn't granted you a lien on the stuff. Second detail point on proper lien perfection I want to mention is titled vehicles. Let's say the shoe's on the other foot now in the borrower counsel, or your counsel representing an unsecured creditor. There may be some opportunity for you, even if a bank lender has a lien on almost everything. Sometimes there are titled vehicles that are lien-free that you can still negotiate with a little bit there. And the third and last thing I want to mention under lien perfection is trademarks, okay? We're seeing more and more wealth in the country move to ideas and intellectual property, one of which is trademarks. The law is in a state of flux on how do you perfect a lien on trademarks so that it's good not only against other creditors, but against the bankruptcy trustee, buyers of the trademark, and so forth. So the best advice is to file both the UCC financing statement and with the U.S. Patent and Trademark Office. So there again, if you don't have that and you're financing a restaurant or a hardware store or something that has a valuable trademark, recorded or not, try to get something on file with the Patent and Trademark Office if you can during the workout stage. You should also check to see if there's some paperwork that disclaims oral agreements and says that the obligors agree that they don't have any supposed oral agreement with you, because otherwise it becomes one of those contests which are politely called swearing contests, but there is another word for it, where the borrower may say, oh, I had an oral agreement that if I just did X, you'd release this, or that really you were only supposed to come after the guarantor if you liquidated all the collateral first, or something like that. Can you improve your hand in this regard in the workout? You bet. You can have the borrower sign something at the beginning saying, hey, I know you want to negotiate here to change the terms of the arrangement, but we want you to sign at the beginning a representation that there are no oral agreements, and that only if we get some paperwork signed after this negotiation will there be a change in it. We also want to be alert to preference day counting, okay? Got a little calendar going there, both as to your creditor and to other creditors. And obviously those of you who represent primarily debtors have your hat on right to just use the obverse of a lot of comments I'm saying so that you know where your client has legitimate leverage and so forth. If there has been a payment made outside of the ordinary course of business to a creditor that won't get fully paid if there was a Chapter 7 filing, then that creditor has a high incentive, if the payment was big enough, not to bargain so tough that they throw the debtor into bankruptcy within 90 days of that surplus payment, if you will, that payment that they might not have gotten if they were in Chapter 7. Okay? Same thing works for counting other creditors. If you're concerned that the borrower or guarantor has depleted his or her assets unfairly by paying another creditor who was in default or in an otherwise shaky, unusual payment arrangement, keep an eye on the calendar so you know how soon you might want to put the debtor in bankruptcy. also want to talk about works in progress. And here we have a concept that if there's a bankruptcy file, I think one of the Chapter 7 trustees with us today. Yeah, thanks. Yeah, that's what I thought, yeah. You know about equitable apportionment, right? You know, if there's a crop filed before the bankruptcy is filed, that gives the pre-petition lenders at least some arguing room, right? Same thing if there's a big piece of equipment being built, or I suppose you have artists here, you know, somebody has a sculpture that you financed. Have you done any of that lately? No, but any kind of work in progress that is started before the bankruptcy but not completed until afterward will probably be equitably apportioned somehow within the bankruptcy estate if counsel is sophisticated enough. So just consider that in your workout, that you might want to have the farmer plant that crop before they go into bankruptcy, so at least as a pre-petition lender, secured lender, you've got some bargaining room. Similarly, if you're a pre-petition lender, they'll recognize that you may not get the entire value of that work in progress if it's completed after the bankruptcy is filed. This leads logically to the next little subtopic there, which is the planting of crops. This gets into that fine area of agronomy even. You get a little agronomy on a Friday afternoon. Perennial crops. Okay, alfalfa would be the primary one around here in my state where I used to live, of Michigan. You know, you get some cranberries and things like that once in a while. So perennial crops, you pre-petition lenders should claim that you have an ongoing lien on that, since it relates back to a pre-petition planting, and then be alert to that in your workouts. I want to talk about financial statements and cash flow, okay, cash flow projections. You can try as a creditor to get a realistic cash flow projection from the borrower during a workout negotiation. And this can be very handy not only for a mutually successful workout, but if that would fail, sometimes it's a little more realistic cash flow projection than after everybody's lawyered up or has an expert consultant or whatever in a bankruptcy, and now they're presenting often kind of the best case scenario on their cash flow projections by that time that may be unrealistically optimistic, or at least on the very, very optimistic side. So try to get some updated financial statements and cash flow projections. And if you have a pencil or pen and you want to circle financial statements in your outline and put the word signed down, you will do your institution a great favor if you represent any kind of creditor. Because we have had in my short lifetime the advent of the personal computer. And in the older days of banking, the bank would give, or the credit company, the manufacturer, whoever was vending on credit, would give the customer a financial statement to fill out. They would fill it out, sign it. It would have that very nice language at the bottom, right, that says, we promise to update you, etc., etc. If you don't have that in your workout file, get it when you're doing the workout. Because nowadays, everybody has a personal computer, and they spit out their own financial statement, right, Keith? And about 3/4 of the time, it seems like they aren't signed, and it's very hard to legitimately hold their representations to them for falsity or truth in the crucible of bankruptcy if you don't have a signed financial statement. And of course, it's also nice to get a location, condition, and value collateral update. Some judges in Nebraska, including my friend Judge Castle, when he was on the trial bench, now an appellate judge, will require for a replevin case that you identify with specificity the collateral. before they get the sheriff heavily involved and so forth. Any experience on that among the audience? Do your state judges require some sort of specificity, or are they okay with all equipment, including but not limited to that sort of thing? Who's had some experience with that? Anybody? Yeah. What?
I've had judges sign it with just equipment.
Yeah. And that's the dominant theme in Nebraska and Iowa and Missouri, but it certainly helps, again, to eliminate the dispute between Uncle Pete and your borrower may now favor Uncle Pete, right? Because if the borrower thinks I'm going down anyway, I might as well have these tractors and stuff be owned by Pete. So it does help you if you get a list of their location, condition, and value. And the condition will help too, just in making a realistic assessment of your credit situation. Accounts receivable, aging, and a list. There again, as we become more and more an idea state, even in the Midwest, we're going to get more and more accounts receivable as part of lending. And even in a farm economy, we see some accounts receivable owed for, a feedlot might owe for this or that delivery, and so forth still. So try to get an account receivable list and aging so that you can effectively collect directly as a creditor if things come to that point. Similarly, you borrowers counsel, this could be a potential win-win situation here. If your client just doesn't have the resources to pay you to collect legitimate debts that have been hanging out too long, maybe you can coordinate with creditor counsel and have them collect them into a lockbox or something so that this potentially valuable asset does not die on the vine. And of course, computer access. More and more, we do need to get into the computerized records of our obligors. And what better time than a workout to have them provide you with appropriate passwords and training so that you know how to access their computer records if it would ever come to a seizure situation. Now, will borrower counsel permit that? Often they won't, but there again, if it's a sophisticated enough organization where they've actually had some software created for them, I think they should understand that, look, if you're carrying this asset on the books at a high level and you want us to give you credit for it, it's appropriate that we know how to get to the source code and object code and maybe some of these other technological situations I can explain during the break if anybody has any questions about those. Okay? So then again, if you ever do a repossession situation, you can actually make use of the valuable data. Inventory, similarly, including feed, you want to make sure you know how much of that the borrower is claiming, where it is, who owns it. Is it owned by, a cattle feeder but just hasn't been delivered yet? Is it owned by your customer who might be a grain farmer and so forth? You may want to write to the obligor, fax them, email them a letter at some point saying, don't dissipate the inventory. However, if that's feed, it gets tricky, right? Because both for humanitarian reasons, but for economic reasons, which you're hired to promote for your organization, if you work for an organization. You want to make sure the animals living off the feed don't die, so just be sensitive to that as you're writing the letter. Sometimes we write a letter in an ag situation in a workout saying, hey, we're happy to talk with you to try to arrange this, but we need to talk, and unless and until we talk, we don't want you to use any feed or other inventory after date X or something like that. or only use it on your own animals, or some sort of arrangement. Talk to a lawyer if you get to that point. Talk to a specialized lawyer if you get to that point. Who owns the feedlot grain? That can be an issue. Does the feedlot own it? Has it just been banked there, in a grain bank? Same thing with horses. You can get some representations on a financial statement, but here's where, in states like ours, the extra know your customer and know your neighbor factor can work to your advantage, okay? Where you can actually also check with the feedlot itself and say, hey, Pete says he owns X number of bushels of grain at your feedlot, can you verify that? Or vice versa, if you're financing the feedlot, you could go to some of their customers. Ashby Feeders Inc. says that it owns all the grain, none of it's in a grain bank. We just wanted to make sure you agreed with that and so forth. Horses have another issue. Are they livestock, Caitlin, or are they a consumer good? They got a name, that sounds like a consumer thing, but have they been depreciated on those business tax returns? And that, of course, gets to the concept that you can't have your horse and ride off with it too. So if you're going to depreciate it as a business return, fair's fair, but then it's encompassed by that lender's lien on all livestock, right? If you're going to treat it as a business animal. You can get this all clarified in a workout agreement if you have appropriate savvy and bargaining power. I want to talk about something that's often missed in front-end lending. When things are happy before the manure, let's say, hits the fan, okay? But we have some front-end lenders in the room and maybe counsel for large ag operations and so forth. You really want to look to make sure your borrower that has a lot of animals is not in a landlocked situation where they're relying on spreading manure on the neighbor's land, right? And if that's the case, then you as a bank doing a workout or as a creditor doing a workout need to go to the neighbor while everybody's still halfway cooperative, right? And say, we would like you to agree that if we ever take over this operation, that for a reasonable time, you'll let us spread manure just like you did with Caitlin's client, Debtor, and then we can have a mutually satisfactory relationship here, even though our borrower's landlocked and needs some place to spread the manure. Same thing with truck access, right? If you have a trucking operation or an operation that even uses significant trucks, but has to turn around on the neighbor's land, that neighbor may be happy when the borrower's doing it, but a little feisty when the lender repossesses the operation and then needs to, because of the circumstances of landlock, turn around on the neighbor's land and so forth. You could argue there's an easement that's developed over time, but much better to deal with those issues at the time of a workout. What questions or comments do you have so far? Questions or comments? As we talk about intangible assets and moving toward that more, we're also seeing LLCs, limited liability company. Well, let's say a person has 3 or 4 of those, but they've also signed as an individual a blanket financing statement with Keith's client. Keith's eyes light up and he says, I think LLC membership units are a general intangible, okay? And therefore my blanket security agreement encompasses that. Now I recognize that state statutes limit often the extent to which you can come in and run the limited liability foreclose on it and so forth. But be alert, please, to the concept that you may have a lien on those limited liability company membership units if you have a blanket lien on the individual that includes general intangibles. If you don't, that's something they can do for you, perhaps. Some people will say, I'm too broke to pay, and I don't have my tax returns done yet, and so forth, so I can't even give you a copy of my tax returns as sort of something that I do for you in a workout lender, but I want you to be patient. Well, what can you do for me? One thing they sometimes can do for you is pledge those limited liability company units. Gee, that was a bonus comment. I didn't even have that on the slide. Agreement to your debt amount. This is basic. This is Workout 101. We'll move back to something that affects all your borrowers and obligors. Have them agree to the debt amount, that there's no offsets for